Okay, good afternoon, everyone. My name is Ian Speir. I am an attorney. Most of my practice is representing religious organizations. I know enough about tech and AI law to be dangerous, and so I'm going to talk about some emerging trends in this space and going to try to fit it into our 30-minute time slot here. There's at least a semester's worth of content to talk about. My goal is to hit some highlights for you and potentially to raise some questions for you that you'll be able to raise at a panel that we have later this afternoon. There are some things I'm going to skip just in the interest of time. Here's our roadmap for this afternoon. I've tried to be alliterative here, so we're going to talk about deplatforming, data privacy, deceptions and deepfakes, death and digital resurrection, and finally, duplications and derivatives, which is my alliterative attempt to talk about copyright. So let's get into it. Deplatforming is an area of risk for a lot of organizations, especially religious organizations. It encompasses a lot of different areas: censorship, delisting, deplatforming, being kicked off of online platforms or social media. Debanking is another risk that you probably have heard about in this space. Here are just some headlines. This is just a small fraction of what's been happening. Books delisted from Amazon, people being kicked off of Twitter or Facebook, and debanking was in the headlines recently because of a hearing last month on the weaponization of the federal government. This is a subcommittee in the House of Representatives chaired by Ohio Congressman Jim Jordan. And I don't know if you followed that hearing or saw some of the headlines out of it. The topic was how big government has colluded with big banks to surveil Americans' private financial data. That surveillance was predicated on core political and religious expression. It impacted religious organizations. It impacted people of faith. Some of my friends at ADF, the Alliance Defending Freedom, were targeted as part of that and testified at the hearing. Deplatforming raises a number of legal issues. I just want to hit some highlights for you. I want to talk about terms of service that you should be looking out for. I want to talk about a federal statute called Section 230. And then we'll get into some potential claims or limitations on the ability of platforms to actually deplatform organizations. This is you can go to this website, the Viewpoint Diversity Score. 64% of companies, according to this score, have policies that contain vague or unclear terms under which they can censor content or deny service. I'm just going to take you through some examples. Here's Bank of America, which has debanked at least 2 small religious nonprofits in the past few years. This is from their terms of service. They can debank you if you would cause them reputational harm, brand damage, or if you are promoting what they consider to be intolerance or hate. PayPal, same thing. You can be kicked off of their platform, not allowed to use their service if, in their view, you are promoting hate or intolerance that is discriminatory. These terms have no further definition, so this is essentially within the discretion of these companies to decide what they consider hateful, discriminatory, etc. This is from Intuit MailChimp. So if you're using MailChimp for email service and marketing, same kind of terms. Acquia is a digital platform management company that some of my clients use, so I've been forced to look at their acceptable use policy. Anything that's otherwise objectionable, they say, is prohibited. Can't use their platform for that. So these terms of service you should actually pay attention to. They give wide discretion to these companies to limit your use of the platform. There are some counterexamples of actually good terms of service. This is WordPress. They say that they strongly believe in freedom of speech. They prohibit certain narrow categories of content: illegal content, IP infringement, threats of violence. But there's no discretionary catch-all where they could kick you off their platform for really any reason. So WordPress is, at least in word, at least in terms of its terms of service, what it says, it's committed to freedom of speech. Okay, I want to talk about Section 230 because this is relevant to the terms of service that these platforms promulgate. I'm not going to read you the text of the first section of Section 230C1, but basically that's a federal statute that says platforms, anybody providing a digital platform, social media companies, etc., they're not liable for content that's posted by a third party. Essentially says that that third party's content is theirs, and the platform isn't deemed to be the speaker or the publisher of a third party's information. And then this next section of the statute says that a platform is not liable for actions taken in good faith to restrict content on the platform. That is a whole list of adjectives there, and you see that term at the end, otherwise objectionable, which you'll find that language in terms of service, and it basically says a platform can censor or remove content or remove users entirely, even if that content is constitutionally protected, even if it would be deemed free speech or it would be deemed religious speech by your organization. As long as they take that action in good faith to limit your content, this federal law, Section 230, protects them. Now, this language raises some questions for us. You guys can advance it in the back, feel free. There we go. Oh, go one back. Or I'll go one back. There we go. All right, what is good faith under Section 230C2? When a platform removes your content or kicks you off, when are they acting in good faith? The answer is nobody actually knows. It's not an issue that's been litigated very much. During the Trump administration, he issued an executive order that said when these platforms are engaged in viewpoint discrimination or forms of political bias, that's not good faith. That executive order was rescinded by the Biden administration. What happens if a platform like Bank of America or a platform like Facebook or X, Twitter, what if it's engaging in racial discrimination? So what if it just kicked off all people of a particular race or ethnicity? What if it said Christians or Jews or Muslims are not allowed on this platform? Religious discrimination, would that qualify as good faith? Maybe, maybe not. It's not clear. Courts haven't answered that question yet, but there has been some, and there will probably continue to be litigation around that. What about AI? Is AI protected under Section 230? So as these platforms are not just hosting content from third parties, but are actually, through chatbots and other means, are engaging in their own speech and creating content as part of a search engine, for example, or some other means, is that protected by Section 230? And the answer is probably not. So here's my attempt to give you a sense of what Section 230 is all about. It's based on the notion that platforms like social media companies are essentially passive conduits of other people's information. And there's a kind of spectrum of passivity here, but you can imagine things like an online bulletin board, which just posts whatever, just displays what somebody else posts. A search engine, a kind of ranked algorithm, somewhat less passive, but it's still just delivering results from someone else. YouTube and Google, they now have these recommendations. I think a lot of tech companies have recommended content now, so they have a profile of you, of a user based on your web activity, and so they'll deliver content that they think you're going to like, so they're making recommendations to you as to what you should access, what videos you should watch, what content you should view. The courts have basically said that's all passive activity that's protected by Section 230, so if there's content hosted on these platforms that's harmful in some way, that's defamatory, that aids and abets a crime or terrorism, the platforms are still not going to be liable for that. But at some point, there's a line that these companies are going to cross in which they become a publisher or a speaker of relevant information. And so, of course, now as you are typing your search into a search engine, you're getting not only ranked algorithm search results, but you're getting a chatbot that's sort of creating content and giving you information that's developed by the AI system working in the background there. does that turn the platform, like Google or YouTube or whatever, does that turn them into a publisher or speaker of information such that they no longer are going to have Section 230 immunity for, say, harmful speech that the AI bot is projecting based upon your search? And there are at least some legal commentators who are starting to say that indeed that crosses a line and will not be protected by Section 230. This is from a website called Lawfare. Courts will likely find, this commentator says, that ChatGPT and other LLMs are information content providers. They're actually speakers. They're not just hosting content from some third party. They're actually developing, creating, and publishing that content. And in some cases, these chatbots, to the extent they are producing harmful information that could be a source of liability, Section 30, the federal law, likely will not protect them. Other potential claims against platforms, social media companies, others hosting content, could be based on the notion that they are common carriers or they are public accommodations. Justice Thomas from the U.S. Supreme Court has suggested this kind of theory. And the idea is that like a telephone network or even like a train, like a railroad company, these platforms are carriers of information of other people and thus should behave like common carriers, which is to say they should not be able to discriminate. They should treat all their customers alike. So whether they're religious, non-religious, whether they're liberal or conservative, these platforms should not be censoring content based upon viewpoint or based upon religion. And so perhaps you could bring claims against them or impose liability on them under the theory that they're sort of like common carriers. There are other sort of cases that are percolating through the courts right now. Are these platforms private speakers in their own right, or are they essentially state actors? The Fifth Circuit last year, which is the federal appeals court that covers, among other states, Missouri and Texas, held that close cooperation between the Biden administration and the social media companies related to COVID resulted in those social media companies becoming mouthpieces of the state, if you will, and thus subject to constitutional standards, and that they violated the First Amendment when they censored COVID-related speech. The Supreme Court, for its part, is skeptical of such a claim, so this case has not yet been decided by the Supreme Court. A decision would be expected, I think, in June of this year. And Justice Kagan, who's one of the justices, kind of expressed the view of the court, I think, that the government communicates with private companies, social media platforms, newspapers, all the time, constantly. And if that becomes a basis on which to hold the social media companies to government standards like the First Amendment, she thinks that's going a little bit too far. We will wait to see the outcome of that. As this problem has percolated, there have been various state law proposals to impose liability on social media companies for deplatforming decisions. Florida has a law, Texas does. Tennessee has one specific to banks. The 11th Circuit has struck down Florida's law. The 5th Circuit has upheld Texas's law. So that case, there's another case at the Supreme Court on whether states can regulate social media companies and impose liability on them for censorship decisions. I think the court is skeptical of state attempts to do that as well. If you are worried about this within the context of your own organization, there are potentially ways that you can limit the ability of some of these platforms to censor you, deplatform you, kick you off. Think about building what I would call anti-deplatforming clauses into your contracts. I've given you some examples here. I'm not going to read them to you. If you'd like to talk about that, I'd be happy to speak with you about it. I've had limited success in doing that for some of my clients, so we can talk through that. Data privacy, this is an area of increased attention from both federal and state lawmakers. It implicates rights of consumers. There's also First Amendment questions for ministries. This is a quote from Jordan Peterson. It was actually at that hearing on weaponization at the subcommittee in the House, talking about the fact that our very identities have become data for many companies, and your organizations hold data on people. Many of my clients have data on their members, on potential targets for evangelism or other ministry efforts. And so what are we doing with that data? Are we adhering to new laws that keep cropping up around data privacy? This is a map of data privacy laws across the United States, and it's from an International Association of Privacy Professionals. That's what the IAPP is there. It's updated pretty regularly. Some of these data privacy laws specifically exempt nonprofit organizations like California and Utah. Some of them specifically do not exempt your nonprofit organization to the extent you are part of one of those. In Colorado, where I live, the question is not clear and raises all sorts of interesting legal questions. Data privacy involves consumer rights to access their data, to correct it if it's incorrect, to delete it, to port it, to bring it somewhere else, and then to opt out of certain data-related practices like targeted advertising. For ministry organizations in particular, there are First Amendment issues as well as just generic legal issues. Do you have a privacy policy on your website about how you're using data? When you're collecting it from, say, someone who's attending your conference or some other source, what sort of information are you giving them about your data practices? You need to be adhering to those to the extent you have those privacy policies. I'm going to skip over statutory questions. There are really hard, I think, First Amendment questions that have to do with your communications with your donors, with members if you are a membership organization, if you are discipling people, students, or others. Can the government, through data privacy laws, restrict the ways that you communicate and demand that you, for example, obtain opt-in consent from these individuals? That impairs your communication with members or others that are sort of religiously significant. First Amendment lawyers would say the government probably can't go that far, but so far we don't have great guidance on that. It's something to be on the lookout for. And it depends on that map of state law. It depends on where you are located, particularly in the United States. Of course, the EU also has the GDPR that I know many of you are compliant with or worried about. Deception and deepfakes. This is third part of our roadmap here. There's not a ton of law around this. There's a lot of headlines. There's a lot of worries. We have deepfake technology that's impacting pop culture, Taylor Swift. War, this is the war in Ukraine. You see a headline there from NPR. Impacting elections and politics, fake Joe Biden robocalls. The FTC is concerned about deepfakes. In this piece, it has suggested that software developers, people using or creating deepfake technology, might be committing unfair trade practices of various kinds. Of course, it's an interesting issue because if you search for deepfakes, you get sponsored results like this one, deepfake.ai. There's another one that's going to come up here. I think it's called Face Swap. There we go. Face Swap on their website very clearly says they've got a manifesto that you can see that on their menu. That's where this appears. Face Swap has ethical uses, they say, political commentary, movies, etc. YouTube is beginning to crack down on synthetic media. It's worried about this problem. It's now requiring AI disclosures. There are good uses of deepfakes. We've all experienced them. We have Harrison Ford as quite a young man in the latest Indiana Jones. And I'm sure you saw, I believe that's from Rogue One, where Carrie Fisher is sort of reconstituted as young Princess Leia. And I just had to throw that in there because it's one of the greatest lines in all the movies. I don't know if you guys, this was new to me as I was researching this presentation. An event of moon disaster is a speech that was written for President Nixon in case Apollo 11 turned out badly for the astronauts. And they've created a deepfake of President Nixon reading that speech, and you can find it at moondisaster.org/film. And it's pretty incredible to watch that. So there's at least sort of, permissible or at least interesting uses of deepfakes. That's the copy of the speech and a little bit from the website there that you can go check out. Keep trying. There we go. CSIS is a think tank in D.C. This is an interesting report that I read, government use of deepfakes. When are they permissible for governments to use, either to combat, to protect national security, to combat, problems of war? Could you use a deepfake when you know that the underlying sort of portrayal is true, even though you don't have an actual recording of the person, their voice, or a video of them doing something? Is that a permissible use of deepfakes? So think tanks, government officials are beginning to wrestle with those questions. A lot of this is Wild West when it comes to the law. There's not a ton of law around it. There's barely any ethics around it, and so that actually applies to this next category as well. This is the first known Chatbot-Associated death from March of 23, so this is about a year ago. Belgian man dies by suicide following exchanges with a chatbot. Could the creators, for a lawyer, the question is, could the creators of that chatbot be liable for what resulted out of this exchange where the man ended up committing suicide after his exchanges with the chatbot? There's other kind of interesting ethics issues. So Anthony Bourdain writes a letter. As part of a documentary, they have a deepfake of his voice reading from something that he wrote. Is it ethical to do that, even though he never spoke those words, he only wrote them? Does there need to be a warning to the audience? And then you can imagine, like these, for legal purposes, you can imagine this can lead to interesting questions where the speech can be harmful, or it can be portraying someone in a false light. Maybe it invades their privacy even after their death. So we've seen this already. AI is bringing film stars back from the dead, and there are sort of interesting First Amendment questions that get raised with this. What rights are you signing away when you agree that your image and likeness can be used? Can the movie companies just take your image and likeness and use it for their own purposes? The other issue is what I call digital resurrection. I wasn't familiar with this issue until recently, dead bots. So this is a story from The Conversation. This gentleman, Joshua Barbeau, a grieving fiance, loads up his late fiancée Jessica's content into a chatbot program and essentially is able to chat with some version of her after she had passed away. Is that ethical to do? Does the family have any rights to shut that down? What rights does he have as the sort of grieving fiancé? These are, again, sort of Wild West questions, not entirely clear. The last thing I want to talk about, which is what Matthew highlighted before I came up here, is copyright issues that particularly involve AI. I'm especially proud of that little image because I'm not an artist at all, but the AI machines can create interesting images for us, so I asked it to give me an example of an old-fashioned writer sitting at his desk with a candle. And I think it said something like, with a weird machine sucking information out of his head, and that's what it came up with. So it's a little bit less gruesome than I suggested for it. So it was protecting me against something strange. Anyway, under copyright law, especially with these chatbots and with LLMs, with the large language models, there's really two questions. One is, I guess not limited to LLMs. The LLMs question is the infringement question. So as content is loaded into these LLMs and then as content is being generated out of them, is there an infringement of copyright that's happening, either because of the copying, the reproduction itself, or because of the derivative? The first question is really interesting too, is can AI-generated works in one form or another be subject to copyright protection? So actually I'm going to start there. The current law, this is the closest I can get you to sort of actual legal principles at the moment. AI-generated works are not copyrightable due to a lack of a human author. That's the position that's been taken by the U.S. Copyright Office, as well as by, not quite courts yet, but at least by the U.S. Copyright Office. And then finally, machines, such as software engines or LLMs, cannot be listed as copyright owners. It's got to be a human author. I have a prediction that particularly impacts that first bullet, which is that AI-generated works will be copyrightable eventually, as long as there's some element, some minimum element of human creativity involved in the process. And I want to explain to you why I think that. Here we go. So in law, what's old is new again. This is a case from the late 1800s. And it's a copyright case, and it was the first copyright case to involve a photograph. The photograph was a new technology at this time. This photographer named Cerrone takes an image of Oscar Wilde. You can see the original photo there on the left. An advertiser of dry goods essentially steals the photo and uses it for their own advertising purposes, doesn't pay a license fee, and the photographer, of course, sues, claiming copyright infringement. So the case is called Burrough-Giles or Burrough-Giles lithographic versus Cerrone from 1884. And the advertiser's argument, I've sort of given you the essence of it. It was basically that a photograph is a mechanical reproduction of reality. There's nothing original about it. All you did was use a machine to represent an existing object, namely Mr. Wilde. You used a machine to reproduce a scene that already existed in the world. So there's nothing copyrightable about it. It's not original in any way. That's the advertiser's argument for why it could take that photo and use it at will without paying a licensing fee. The Supreme Court, it turns out, as early as 1884, disagrees with that, and they say, look, the photographer Cerrone, he made the photo by doing a bunch of creative things. He posed Mr. Wilde, he selected and arranged the various elements, including costume and the background, etc., and he suggested and evoked the desired expression. So I guess he gave him some instructions about his posture, perhaps, or his face, or something. Summarizing, the Supreme Court said, this scene didn't create itself in the photograph. It required human creative inputs. Therefore, photographs are copyrightable. Okay? Well, you can probably sense where I'm going to go with this. This is a piece of AI-generated art from a gentleman named Jason Allen. He's in Colorado, the Denver area. That's the title of it. I believe that's probably French. And I'm not going to pronounce it. My friend Eric is somewhere in the room and could do that for me. He entered this piece of AI-generated art, which he created. I forget what he used for it. I think it was Midjourney. He entered it in the State Fair art competition in Colorado without disclosing that it was AI-generated. He actually won that competition, he won first place, revealed after the fact that it was AI-generated, and there was quite the controversy as a result. There are some headlines for you. He sought to register the copyright in the image. The Copyright Office denied him a copyright because it contains what it called more than a minimal amount of content generated by AI, and thus it can't be registered. I actually spoke with Mr. Allen's lawyer. They plan to appeal that decision sometime soon. Yeah, it was Midjourney. So if you look here, these are all the sort of things that he did, the way he queried the engine, so to speak, to get the image that he wanted. He refined it in various ways and used a number of different text prompts in Midjourney to get that image. And so the summary of that is, just like in the photograph, there's a lot of human creative input that goes into these AI-generated images. My guess is the U.S. Copyright Office will eventually recognize that this is copyrightable. This is a different AI-generated image. Mr. Thaler owns this thing called a creativity machine. It's LLM, or it's some kind of software engine that develops images. He sought to register the copyright in the name of the machine. That has been denied, and he has appealed that decision. That I expect he will lose. So whereas I think Jason Allen will eventually have his image copyrighted based on his human creative inputs, Mr. Thaler's attempt to have the machine own the copyright probably will not succeed. U.S. Copyright Office is studying this issue, and then there are a bunch of pending lawsuits on this second issue of infringement. There's no way I have time to go through all of these, but these are lawsuits against the LLM companies, Stability AI, OpenAI, Meta platforms, GitHub, which is, of course, Microsoft. And the authors, or the artists of the artwork, or the authors of the books claim that the ingesting of their content, their protected copyrighted content into the LLMs is a violation of their copyright. And of course, the derivatives that come out of that, the ability to summarize, including to summarize in that author's own voice or to speak in that author's own voice, are both sources of liability. So both the copying into the training data set and the derivative works that are generated out of it. Here's a quote from one of the complaints. AI models are copyright laundering devices, promising customers the benefits of art without the costs of artists. And it's fairly persuasive because copyright is concerned with sort of replacing the market for the artist with a substitute and not paying the requisite fee. There are various problems with the claims, and they're sort of unique to these particular lawsuits. And I don't know that these lawsuits are going to give us firm answers on the future of copyright protection or lack of it for LLMs and the content that they're ingesting and also generating. And I'm just slightly over my time, so I'm going to give you the quick takeaways. For combating deplatforming risks, think about platform redundancy. So if you're a ministry that uses YouTube, for example, think about having your videos on another platform in case YouTube ever shuts you down. And you can imagine that extrapolating that principle to a number of other platforms. Think about anti-deplatforming clauses, like I mentioned. There are potential legal claims based on public accommodations, common carrier, even First Amendment claims that could be made. Data privacy is something you need to be thinking about and talking to counsel about. You need to be adhering to your privacy policies. Take seriously what they say. Actually read them. And analyze religious freedom and free speech protections. There could be First Amendment limits on the extent to which, at least in the United States, states and other regulators can impose liability upon you for your data practices. So keep an eye on that. And then finally, for using generative AI right now, authors and artists don't have copyright protection, at least with respect to AI-generated works, but I expect, again, that will change in the future as long as there's some minimal creative input into the art, even if it's generated using an AI tool, much like that photography case from 1884. I expect the courts to recognize that form of art as sufficiently creative and original to have copyright protection. When it comes to the LLMs, the pending copyright suits right now have the potential to limit the viability of their business model. You see, I crossed out kneecap. I gave a presentation like this about 6 months ago, and those lawsuits were just getting off the ground. And they came out pretty strong, and there was a lot of commentary that suggested that they could really kneecap the business model of the LLMs. Like I mentioned, there are various problems with those lawsuits, so they will probably not have the drastic effect that maybe some originally thought that they would have. Okay, that concludes my presentation. I want to invite up here Damian Dasman for the next presentation. Thank you.